Yes, dear faculty.
Obliged, Lord. So before lunch, I was endeavouring to explain that in my submission, what we see in McLaren Murdoch is Lord Drummond-Young saying that he is content that Scots law should follow the majority in Panatown, but then going on to offer what, on closer inspection, is an overly expansive description of what that case holds in terms of the majority. And in order to make that good, can I ask the court to turn up Panatown? And in particular, can we start at page 809 in the bundle? Now, bearing in mind what I've already said about Lord Drummond-Young's description, I suggest one finds telling the passage at page 809, letter H. Lord Clyde, very shortly into his speech, I find no reason to question the general principle that a plaintiff may only recover damages for a loss which he has himself suffered, but there are exceptions to that principle. So that's the general rule. That's Lord Clyde's starting point. And as I submitted just before lunch, if Lord Drummond-Young is right, that general rule is gone. Because of universal application, all you've got to do is find a breach and somebody somewhere that suffered a loss. So that rather points away from the synthesis offered by Lord Drummond-Young. And I suggest the same is apparent as we read on. Page 816. At the foot of that page between G and H, His Lordship cites the Albazero and Lord Diplock. And we see there, the Court's very familiar with this passage, but it hasn't actually been read to them yet, as an application of the principle accepted also in relation to policies of insurance upon goods, in a commercial contract concerning goods where it is in the contemplation of the parties that the proprietary interest in the goods may be transferred from one owner to another after the contract has been entered into and before the breach causing loss, an original party to the contract, if such be the intention of both, is to be treated in law as having entered into the contract for the benefit of all persons who have or may acquire an interest in the goods before they are lost or damaged, and is entitled to recover by way of damages for breach of contract the actual loss sustained by those for whose benefit the contract is entered into. That is the clearest possible distillation of the narrow ground. And there is no suggestion by Lord Clyde that he's doing anything other than following the narrow ground. Page 822, still in the speech of Lord Clyde, and just above, in between letters B and C, 2 points that are of moment. First of all, Lord Clyde says, since Parliament has recently made some inroad into the principle of privity, but has stopped short of admitting a solution to a situation such as the present, it would plainly be inappropriate to enlarge the statutory provision by judicial innovation. Well, that comes back to my comment earlier about judicial reticence. We've got the 2017 Act. What's the point of it, if my learned friend is correct? And then it's interesting to look at what he says next. The alternative has to be the adoption of what Lord Diplock said in Swain, or described as a juristic subterfuge to mitigate the effect of the lacuna resulting from the non-recognition of a jus quaesitum tertio. Well, Scots law's never required that judicial subterfuge, because we've always had the jus quaesitum tertio, and now we have the 2017 Act. So an inauspicious start for this wholesale development of the law. And that is, I respectfully suggest, very clear when we look to what was said by the other two members of the majority. Page 850 is Lord Jauncey. Page 850, letter D, Lord Jauncey says the starting point is the Scots case of Dunlop, treated ever since by textbook writers, and then the description from the Albazero. Scottish textbook writers have been less enthusiastic. Lord Clyde referred to Professor Gloag's comment. Bell's principles, Dunlop against other cases, is cited as vouching the proposition that risk is continued in the seller was an express or implied undertaking of the risk. And Lord Diplock rationalised the rule in Dunlop as an application of the principle, and we've seen that already. Now that's the narrow ground. Lord Johnsey is absolutely not doing anything other than applying the narrow ground. And similarly, if we go to 853, in the citation from Lord Brown-Wilkinson, it's at the top of that page. This is from Lanesta, or St Martin's. Lord Brown-Wilkinson, in the indented passage there. This is from, yes, it is St Martin's. Again, that's all entirely consistent with the narrow ground. And at 855, letter C to D, Lord Johnsey says, that rule, that's the rule in Dunlop, provides a remedy where no other would be available for breach of contract in circumstances where it is within the contemplation of contracting parties that breach by one is likely to cause loss to an identified or identifiable stranger to the contract rather than to the other contracting party. Again, it's not suggested by my learned friend that he can bring himself within that rule. And the clearest possible description of the narrow ground is found in the speech of Lord Brown-Wilkinson. Page 862, that letter E to F. The narrower ground starts by accepting the basic proposition that A, not owning the land at date of breach can show no compensatable loss. However, the majority of the members of the committee extended the reasoning in the Albazero to cover a case so as to hold where A enters into a contract with B relating to property and it's envisaged by the parties that ownership may be transferred to C, so the consequences of breach will be suffered by C. A has a cause of action to recover from B the loss suffered by C. The clearest possible description of the narrow ground. And without needing to turn it up, that was clearly the view of the Scottish Law Commission, that the Scottish courts recognise the narrow ground. The court will find that in the Law Commission report at 18.25, PDF 1246. Given the Scots law origin of all of this, Dunlop against Lambert, I hope I may be entitled to muse whether Lords Clyde and Johnsey would have expressed themselves in quite the same way if they'd been directed to the correct passage from Gloag on contract. We looked at these passages earlier, or at least one of them, 815 in the bundle. Lord Clyde is referred to page 350 in Gloag. The court finds that at 850, letter B. And in the passage we just looked at, Lord Johnsey at page 850, 850, it seems it's the same passage because between E and F, Lord Johnsey is referring back to Lord Clyde's own comment. I beg leave to suggest that was the wrong place to look, and the following is the result of the industries of Malerna Jr., Mr. Reid, over the weekend. I hope the court got the additional extract from Gloag.
Yes, they arrived this morning.
So if the court turns that up, it's just 4 pages. First page is the frontispiece. The second page is the table of cases from Gloag second edition, which I respectfully suggest explains why page 350 was looked at, because Dunlop against Lambert is noted as only being discussed on page 350. And page 350 is the last page in that extract. The court can look at that, but I suggest it's not very helpful. What I suggest is much more helpful is if we turn to page 254, which should be the third page of the PDF. And on the third page of the PDF, lack of interest as objection to title. About 12 lines in, this is Gloag 1929, second edition. And if A and B enter into, does the court have that?
Yes.
Yes.
And if A and B enter into a particular contract with reference to a thing of which A, at the date of the contract, is owner, and the thing is afterwards transferred by A to C on terms which leave A without interest in it or liability for its state, the plea of want of interest will debar A from enforcing the contract against B, nor can he obtain damages for B's breach of contract, because in the circumstances figured, he has suffered no loss. So, Gloag, writing 90 years after Dunlop against Lambert, did not even consider that the narrow ground claim would be available. And we can see that, and we can see why, as we read on. In Bloomer & Co., Bloomer employed the defenders, a firm of ship engineers, to fit up engines in a ship. This ship they had already sold to Ellis & Son, and in the contract of sale had protected themselves from any liability for late delivery owing to the delay of the engineers. Defenders failed to complete the engines within the contract time, and an action of damages was raised by Bloomer and Ellis as joint pursuers. It was held that Ellis, who had in fact suffered loss, had no title to sue because they were not parties to the contract. The instance of Bloomer also failed in respect they had no interest. As they were not liable for the delays of the engineers, and as they had no interest in the ship, they'd suffered no loss, and were therefore suing for damages which they had not sustained. Well, it might be said that Bloomer is the direct ancestor of this case. Pretty much indistinguishable. And it certainly provides no support for what is contended for under Scots law by the appellant. And just to complete what Gloag said, reading on again, in Edinburgh United Breweries, a decision, be it noted, of the House of Lords, in Edinburgh United Breweries, A sold a brewery to B. The amount was fixed on representations made by A. B resold to C at an enhanced price without any relation to annual returns, and the brewery was by arrangement conveyed by A to C. It was afterwards discovered the amount of the annual returns had been overestimated owing to fraudulent entries. B and C brought an action concluding for reduction of the original sale by A on the ground of misrepresentation involved in these false entries. It was not shown that the second sale by B to C was open to challenge. The court proceeded on the footing it was not. It was held that neither B nor C had title to sue. B, because having resold the brewery, he had no further interest in the matter, and C, because he had no title to found on misrepresentations not made to him. Now, quite accept that that was a case about reduction of a contract and not a claim in damages, but it would be rather odd to find that one lacks sufficient interest to seek reduction and yet has sufficient interest to claim damages. So that is why I contend, suggest, submit that if Lords Johnsey and Clyde in Panatown had been pointed to page 254 rather than page 350 of Gloag, we might very well have seen something rather different. Now, I'm not arguing for something revolutionary like my learned friend is. I am simply seeking to meet the case against me, which is that there should be an expansion of the law as understood in terms of the narrower ground and so far as it exists, the broader. And my suggestion is not only is that not rooted in principle, not only is that not supported by precedent, it cuts directly across what we see written by the leading writer on contract in Scotland. If I move then from what my submission of the law actually is, can I make some observations on what I suggest is the fundamental incoherence of what is being proposed? And I've touched on this already. It's the width, it's the all-encompassing width of it, now restricted only by material interest and remoteness, and I'll take these in turn. Material interest, let's start with that. If I purchase a car and it's defective and it repeatedly needs to be returned for repairs, well, is there not a material interest on my part in my family and vice versa? So, can I sue for damages on behalf of my son, who's now got to walk to school, on behalf of my wife, who's now got to get taxis to work, on behalf of my mother-in-law, who can no longer have the lasagna brought round by her daughter and has to use Deliveroo? That's all the consequence of what's urged upon the court. That's the sort of expansion we're talking about. It's unprincipled and it's substantial. And looking to the corporate sphere, what does material interest mean? Well, it's easy, isn't it, on the appellant's analysis. In this case, wholly owned subsidiary, what's the problem? But where are the limits? So is one share enough to have a material interest? In BP, surely not. In a company that's only got one issued share, surely. But what if there's 2 shares? What if there's 3 shares? What if there's 4 shares? Where does it stop? And my learned friend only looks down the corporate chain. He says, wholly owned subsidiary, there you go. Well, we not look up. If being owned is enough to give material interest, surely ownership is enough. So it's shareholders. Is that what we're saying now? And how much interrogation of this does there need to be in the familial line? What if Alf and Claire are going through a very acrimonious divorce? Does that have to be tested? Do you still have a material interest in a spouse to whom you don't speak and have no intention ever to speaking again? It's all unprincipled, undefined, and undefinable. Now, the point has been made repeatedly in the courts below and again here. How do you define material interest? And the appellant has been unable to do so, not because of any lack of intellectual capacity on the part of my learned friends, but because the concept is inherently vague. And that alone is a reason for rejecting it. And what I'm putting forward in terms of the shareholders, in terms of the lasagna-deprived mother-in-law, this is not a parade of horribles. This is daily Scottish commercial practice. The inability of the appellant to answer these questions demonstrates just how unworkable it is. So next, and this is where I said I would try and address my Lord Stephen's question. Next, the appellant says, don't worry, remoteness. Remoteness is the answer. It will control the scope of recovery. That's illusory in my submission for various reasons. First, the appellant argues that the respondent should have foreseen that lost profits would arise if its breach caused the premises to close. Well, if that's the test, remoteness provides no limitation at all in any case where premises are let for commercial use. The landlord always knows his premises will be used for trade. The landlord can always foresee that breach will cause trading losses. And the only question is whose losses, and that's the one thing that the appellant contends is solely irrelevant. But it's trite that the remoteness test in contract, reasonable contemplation at the time of contracting, is applied by reference to the type of loss, not by its amount. So if I were standing here and saying, oh, it's too remote, then the inevitable answer that would come from a learned friend to the applause of your lordships and my lady is that is the wrong question. The only question for remoteness is the type of loss foreseeable? The fact that the quantum of loss is wholly unforeseeable is neither here nor there. It's not a defence. So that means the respondent's exposure is wholly unpredictable and wholly uncontrollable. A landlord who lets premises to a modest cafe can find itself liable for the lost profits of a hedge fund operating from those premises through an undisclosed licence, simply because trading losses were foreseeable as a type of loss.
The lease is unlikely to allow for two such diverse uses.
On the particular facts of this case, I quite accept that. But equally, as your lordship has observed, the user clause is pretty wide. It doesn't take the extremity of the argument that I see under reference to the hedge fund to be able to envisage very different quantum of loss. Maybe not very different types of loss, but very different quantum of loss depending on who's actually in the premises at the time. And the appellant's argument that remoteness is assessed by reference to what the respondent could foresee trading losses, somewhat in tension with its argument that intention is irrelevant and that the doctrine operates as a matter of law regardless of what the parties knew or contemplated. If knowledge is irrelevant to whether the doctrine applies, why is it suddenly relevant on the question on quantum? The appellant can't coherently maintain both propositions. So in my submission, one does not constrain what's urged upon the court with any meaningful boundaries, either by resort to material interest or by resort to remoteness. The next observation I would have is that, and I've touched on this, what is being urged upon the court is truly an inversion of the law of contract and dealing. This is a doctrine said to be suitable for a contractual relationship, the limits of which both parties are free to set out in advance, where liability usually arises without proof of fault, and yet it's not suitable for a delictual claim, in which there's no ability to set the limits in advance and where proof of fault is always necessary. Now, my Lord Stevens has pointed out there is an exception to that, but that exception is statutory. Services. The legislature had to intervene for services because the well-recognised common law is, coming back to this, if you yourself have not suffered a loss, you can't sue for it in contract or in dealing. That is why, in terms of the Administration of Justice Act, sections 8 and 9, the ability on the behalf of relatives who have provided services gratuitously or who have been denied services of the injured relative, it often is said to have a claim. Of course, they don't have a claim. In fact, the sections say in terms you don't have a claim. They don't have a claim. The section says in terms the injured party can bring the claim and under section 8, subsection 2, has a duty to account. Statutory innovation. So, why is this new liability being imposed in contract? The answer given, and the appellant's case is littered with this, is it's necessary in order to do justice between the parties. That looks awfully like fair, just and reasonable, does it not? And is that not really the province of the world of delict and tort as opposed to the world of contract?
Just trying to think of other examples where there is a duty to account, where you make a claim on behalf of some other person and there's a duty to account. And at present, I'm struggling to think of one.
So, the answer to that, my lord, is that there are all the sorts of situations where it would be recognised that the problem presently facing the appellant wouldn't arise. So if you sue him as a trustee,
yes.
duty to account, fine.
Yeah.
Sue as an agent,
Yeah.
duty to account. But other than that, I share the difficulty. Yeah. There are statutory impositions, and that's it. So the next point that kind of flows from what I've just said is it has always been a good defence to a claim for damages to say, but you didn't suffer that loss. That's always been a good argument. And apparently that's to go now. I mean, we've mentioned the gratuitous care point, the statutory intervention, but let's imagine, and because we're in the world of contract, it's not just a car crash, it has to be, let's imagine I hire a chauffeur to drive me around. And in breach of contract, because he's got a duty to drive with reasonable care, he causes a crash. And my car needs repaired as a result. And let's envisage that I sue for breach of contract and say, I've had to hire a car in the meantime. The chauffeur's insurer very sensibly says, OK, let's see the receipts. And I say, well, actually, I don't have any receipts because it was my son who was driving me around in his car while mine was being repaired. In today's world, that is a complete defence and probably a motion for indemnity costs. In my learned friend's world, it's all good. There's a new claim on behalf of the son for his petrol money and his time. And that only works, of course, where there's a contract. It doesn't work where there's delict, which is wholly counterintuitive. The statutory intervention in the 1982 Act proceeds on the explicit premise that the common law position is you can't recover for a loss you haven't sustained. That is sought to be inverted. And likewise, I've mentioned this already, how do we explain the innovation of the law in Donoghue against Stevenson? What's the point if it's just material interest and remoteness? The law has always treated the inability of third parties to recover under contracts to which they are strangers as a feature, not a bug. The solution, where a solution is needed, is found in delict, in statute, in collateral warranties, in assignation, in the Jus Quaesitum Tertio or the 2017 Act. These are the tools the law has fashioned, carefully and over centuries. The appellant proposes to render that all OTOs in a stroke, and without regard to the consequences, because all that they say is, don't worry, black hole cases don't come around very often. Well, my Lord Docherty's observation, it shows exactly why that's not right. We live in a litigious world. If my learned friend is right, if there is this massive expansion, these claims will be a daily occurrence. What responsible lawyer sitting looking at a claim for breach of contract, if my learned friend is right, wouldn't have to say, in order to fulfil his duty of care, wouldn't have to say to his client, any family members that have suffered as a result of this, or be speaking to the company director, anyone in the corporate chain, up, down or sideways, that suffered as a result of this breach of contract, and if so, we better claim for that. Now, as Dean of a faculty which relies on expansion of litigation, I'm absolutely happy with that, but what I can't see any more than could the Law Commission or can the appellant, or with great respect, can this court, is the downside in terms of economic harm. Now, please don't get me wrong, I understand that floodgates arguments rarely land in this court. But that's usually because they're alarmist in nature and easily dismissed. A moment's consideration of the proposal here, which basically gives a starting point in which all associated companies, undefined, and all family members, undefined, have an interest in each other's contractual affairs. That, I would beg leave to suggest, shows I am not being alarmist. I am signalling the actuality and predicting the consequences. It was that sort of consideration that caused the Scottish Law Commission to draw back from the very limited statutory intervention it had proposed. And bear in mind, what it was looking at was abolition of the recoverability of transferred loss outside contractual provision for its recovery. That was not a course of action that it commended itself. And what had commended itself was effectively a statutory invocation of the narrow ground. The court will see that, again, I'm not going to turn it up, but the court will see that the Commission, chaired of course by Lord Pentland, recognised that even modest statutory extension would create a somewhat arbitrary division in the law. That's page 1251 of the bundle, paragraph 18.55. And the proposed reform was confined to cases where the contract was for work upon property subsequently transferred. Paragraph 18.54 on the same page. And that limited extension couldn't be recommended because the Law Commission didn't have the resources to be able to predict what effect it would have. The appellant seeks recovery in a case involving no property transfer, no known intention to benefit a third party, no communication even of the third party's existence to the contract breaker. And yet this court is meant to be able to be satisfied that it's not imposing something of widespread and dramatic effect. This court is entitled to consider the practical consequences of its decisions for the commercial community. Scotland is a jurisdiction that competes for commercial business. Certainty and predictability of Scots contract law is an asset, not a vulnerability. And what the appellant proposes would inject radical uncertainty into every commercial contract in Scotland. I've said commercial, why have I said that? Every contract, commercial or domestic. No party entering into a contract could know what the full scope of its potential liability might be, because that liability doesn't depend on what was agreed, or on what was known, or even on what was foreseeable, but on the internal arrangements of the counterparty with third parties of whose existence it's completely unaware. The insurance implications alone are staggering. How does one insure against liability for the lost profits of an unknown party whose occupation one never consents to? How does a contractor price a job when its liability extends not merely to its employer's loss, but to the losses of every entity with a material interest shared with the employer? The consequences are either that such risks become uninsurable, driving up the cost of commerce, or they are priced in at worst case levels to the detriment of everyone. As I've said before, this is not a parade of horribles. This is not me being in any way speculative. This is what will happen. None of this can be assessed by the court. It's precisely why it would need far more in the way of what the Law Commission was able to give it in terms of dedicated resources before one could ever be able to come to a solution such as this. And with great respect for all of the undoubted ability to develop the law that inures in this court does not have the tools to consult. This court does not have the tools to look to the business community and see just how bad this might be. Again, that should give it pause for thought.
I've been looking at Lord Gough again, and he discusses the damages that are recoverable on his approach and the approach of Lord Griffiths, and because the damages are for the failure to obtain the performance for which the party had paid, the damages are to compensate for that non-performance, and it's quite clear that both Lord Griffiths and Lord Gough regard the appropriate damages as being primarily the cost of performance. So the cost of carrying out remedial works.
Yeah.
And that's what Lord Griffiths says in Leinster, and Lord Gough approves that. He also accepts that if there's a liquidated damages clause for delay, then because performance within the specified time is part of what's being contracted for, it should be possible to obtain the liquidated damages for the delay. There's no suggestion I can see in Panatown that consequential losses, like a loss of profit by the actual occupier of the building, would be recoverable on this footing.
No, and in fact, there are indications in the authorities to the contrary, and I'm going to take the court to those shortly.
That was why I was comparing your conclusion 3 with the broader concept, because in Panatown it was simply the damages for the non-performance of the contract. So it was the sum required to have the contract performed.
Yes.
Yeah.
So there's an analogy, although you can quite rightly say, well, there's no question of a third party involved in where there's an extant lease and you're still a tenant. You can demand performance of that contract.
Yes.
I see that.
I, as I said earlier, I've never had any difficulty with the third conclusion, and I continue not to have a difficulty with the third conclusion, other than all that the majority in our House were doing in my submission was saying, well, it's kind of difficult to understand why you need that, because your primary remedy is ad factum praestandum. Your primary remedy is specific implement, do the work. And there was never any suggestion that if told to do the work, they wouldn't do the work. So what role was there for that? But as a matter of strict competence, I quite accept that it's always possible to say, to come back to the court, if a decree ad factum praestandum has not been obtempered, then there must be a remedy. It would be remedium. You must be able to come back to the court and say, well, they won't do it, and now they've folded, and I've got effectively a fund in liquidation. I need to claim on that to get the money back. So, if what I've said already is effectively the generics, or the general proposition, in my submission, the appellant's case gets even more difficult to thole when one looks at the actual facts of the case. The contractual architecture. You've got occupation in breach of lease, and the problem that you're trying to found upon something that's in breach yourself is going to be rather difficult. You've got Clause 8 of the licence, PDF 201. The appellant shall at no time become liable to Lynette for any loss arising from the deficiency in the premises. So the appellant has got no liability at all to Lynette. What's the basis for saying it can claim damages representing losses for which it has no legal liability? Lord Pentland was correct in my submission to identify that as fatal to any claim for an accounting, but it's equally fatal to the underlying claim. If you're not liable to Lynette, then the appellant hasn't suffered Lynette's losses in any legally meaningful sense. The absurd nature of the claim becomes even more apparent if one thinks, well, let's imagine that we had this licence and it wasn't without consent, so it wasn't unlawful. And let's imagine it did not absolve the appellant from any liability from the state of the premises. So then you've got the contractual chain claim I mentioned earlier. The Lynette say to the appellant, premises are grotty, we've lost money, give us it back. Appellant says to the landlord, I've got a straight pass on. The answer, if the licence was otherwise exactly the same, the answer to that would be, well, you've got to mitigate your loss. And you can terminate this licence on 7 days' notice. So, if the case was stronger for Miller and a friend, he would be stuck with 7 days loss. And I venture to say we wouldn't be in the Supreme Court if we're looking at 7 days loss. But because it's even worse, because his contract is even worse for him, he can say, well, we just ignore it. We just ignore it. And how can he say we just ignore it? In terms of the written statement of case, res inter alios acta. But that argument is self-consuming. If the internal arrangements between the appellant and Lynette are res inter alios acta in a question with the respondent, then a fortiori, Lynette's losses are res inter alios acta in a question with the respondent. The appellant cannot simultaneously say, my arrangements with Lynette are none of your business, at the same time as saying Lynette's losses are very much your problem. That is wholly inconsistent. It must choose one or the other. And this is the inherent contradiction in the appellant's case. When it suits the appellant, it relies on the separation between pursuer and Lynette. Lynette's a separate legal person, so res inter alios acta. But it seeks to dissolve that separation when it doesn't suit, on the basis or under the guise of material interest. That is precisely the sort of selective veil piercing against which the court and the law turns its face. Lord Justice Coulson in Nederlandse, again, don't need to turn it up, PDF 1071, paragraph 77. Parties cannot rely on the separate nature of companies when it suits them and seek to break down the barriers when it creates difficulties. What this court really has is an appeal to justice. It's not fair, they say. The respondent is escaping the consequences of its breach. As at the outset, that framing assumes what it seeks to prove. The question is not whether breach should have consequences. Of course it does. But whether those consequences should extend to losses suffered by an entity the respondent never contracted with, was never told about, and whose exposure to loss it was entirely out with their control. Justice doesn't operate in one direction only. It was the respondent who entered into the lease with the appellant on certain terms. It priced the lease, it insured the lease, it assessed the risk of the lease on the basis of the law as it was understood to be. It's the appellant who seeks to undo all of that and says, well, otherwise the respondent gets a windfall. But the respondent's not getting a windfall. It's getting the benefit of the contractual bargain it made. The loss the appellant complained of is not a loss that was within the scope of the respondent's undertaking. The respondent undertook to maintain premises let to the appellant for use by the appellant as a restaurant. It did not undertake to indemnify every entity that might, unknown to the respondent, come to trade. And in truth, what the appellant is seeking is not to hold the respondent to its bargain. It's seeking to impose a burden the respondent never agreed to bear. That's not justice. And again, there's been some discussion of this with the court already, but it is important not to lose sight of what's actually being claimed here. There's already a claim for the defects in the premises, the repair costs of the premises. That's all understood. No difficulty. The lost profits, the consequential trading losses of a related entity, not party to the lease, that's what we're talking about. And that matters because consequential losses occupy a specific and carefully delineated place within the law of contract. They are recoverable only under the second limb of Hadley and Baxendale. That is, only if the special circumstances were communicated to and within the contemplation of both parties at the time of contracting. Lynette, not known of, well, certainly not at the time, probably didn't even exist at the time of striking the lease. And for that reason, consequential losses cannot be recovered on the broader ground. And I know my learner friend will say, well, this is irrelevant because I'm not arguing for the broader ground, I'm looking for something else, a third way. But it's of interest to see that, and in line with the discussion with my Lord and the Chair, on the broader ground, consequential losses don't work. Just 3 passages to make that good. Panatown itself, 860. Letter G to H, this is in the speech of Lord Johnsey. Furthermore, consequential loss resulting to third party due to delay and resultant loss of profits would appear to be irrecoverable. A similar comment from David Donaldson QC in And So to Bed, PDF 903.
PDF number?
At 903, my Lord.
903.
Paragraph 54 at the top of that page. It does not appear to me that Lord Griffiths' approach assists performance interests of Party A to a contract envisaged by Lord Griffiths in Linden Gardens no more than the obverse of positive obligations, benefit inherent in the performance of those obligations itself to the exclusion of any further consequential loss. And a similar comment in the most recent of the cases, Swinson in this court, page 1023. Lord Mance, paragraph 53 at letter E. Potential difficulties about the theory of performance interest are that it cannot prima facie embrace consequential loss suffered by the company actually as opposed to contractually interested in the quality of the property, etc. So, despite the fact that on any view, if the law is correctly stated by Lord Drummond Young and McLaren Murdoch, well, the one thing we know he absolutely rejected was the broader ground. That's not consistent with Scots law, he tells us. And yet, the broader ground, even the broader ground, would not allow consequential loss. Where does one get this ability to seek these consequential losses? One doesn't get it anywhere in principle because the consequences are such, I would suggest. It's unprincipled. If the appellant is correct that consequential losses suffered by an unknown third party are recoverable in the way it suggests, then the entire structure of Hadley and Baxendale is undermined. The distinction between the first and second limbs in Hadley become meaningless if the pursuer can bypass the second limb simply by pointing to a third party's losses and saying, well, I've got a material interest. And it doesn't matter whether you knew about it or not. I've got a material interest. So those are the reasons, my lords and my lady, as to why I say the first and second questions fall to be answered in the way proposed by the respondent. That really just leaves the third and fourth, and the third and fourth questions only matter if the court's not with me on the primary argument, and I'm not going to spend over long on it, but it is perhaps helpful, in particular on the third question, just to try and understand the duty to account point. And in particular, in my submission, that exposes a further incoherence in what's proposed. On the narrow ground recognised in the authorities, there is a duty to account. That seems fairly clear. On the broader ground, the innocent party is suing for its own loss. Lord Gough and Lord Millett holding that the promisee's loss is the failure to receive the contracted for performance measured by the cost of cure or the difference in value. It's the promisee's own loss. You wouldn't be holding that on trust for anyone. That's your own loss. And my learned friend says, well, in every case where his third way applies, you'll be holding it, there'll be a duty to account. Well, why? If the third way, he suggests, plainly encompasses the narrower and the broader ground. It's so wide. And if within his third way we've got a broader ground case, why would you be holding it on trust for anyone? It's your own loss. And then the question arises, well, what happens if the damages are paid in the day after they're attached by creditors? Question posed of my learned friend, Mr. Ford. No answer was forthcoming. Again, not because of any lack of intellectual acuity, because the question's unanswerable, because this has not been thought through in a way that is capable of being expressed as a coherent legal scheme. It's my learned friends who come to this court asking for this change in the law. It falls to them to explain how it works. And what is it? Is it a constructive trust? If so, how does that work, given that the Scots law on constructive trust is not the same as the English law on constructive trusts? Every trust has a duty to account, but not every duty to account is the result of a trust. So what is it? There's no statutory obligation. And if one imagines the money being handed over and then Lynette saying, oh, can we have our money, please? The appellant saying, look at clause 8 of the licence. I'm not responsible to you for anything arising from the state of the premises. Why would I give you a penny piece? So they can just hold on to it. If one wants evidence of a windfall in this case, that would be the windfall. Lord Pentland identified this in the Inner House, paragraph 103. How can a liability on the part of the pursuers to account to Lynette for damages be said to arise in view of the express terms of the licence? That's the question he posed. No answer to that is available. If the accounting obligation is unenforceable, as clause 8 suggests, then the appellant could retain the damages, and that would be wholly unprincipled. And the fourth question is easily disposed of. If there is no obligation to account, there is no title to sue. You can't sue to recover another's losses unless you're under an obligation to pass them over. So, trying to tie this all together, I return to a point in many ways in which is the one I began with. Everything that the appellant proposes happens here is happening out with the contractual relationship. It's probably, as here, something of which the contract breaker has no knowledge, against which he can neither predict nor insure. The ability of this court to develop the law of Scotland is unquestionable and unquestioned, but retrospectively to impose this sort of expansion in the law of contract on every bargain ever struck under the law of Scotland, in a situation where it can no more predict the outcome than could the Commission, surely cannot be contemplated. It's not a case in which the law...
I'm just thinking it's really, the point you last made about the duty to account, it's really a problem with Lord Clyde's reasoning, which was then adopted by Lord Drummond Young, because on the narrow ground, where the pursuer is suing on behalf of other people, there's no difficulty with a duty to account because he's an agent. Quite. And he's holding the funds in that capacity. And there's no problem with Lord Goff's broad ground because there, as he puts it, the employer is seeking to recover damages for his own account in respect of his own loss.
Yes.
In a sense, the loss being the loss of the performance for which he had contracted. So he gets the money for his own benefit. And the mystery really is where Lord Clyde's duty to account comes from.
Well, Lord Clyde's duty to account, my reading of what Lord Clyde was saying is he's simply adopting what was said by everyone else, which is that in a narrow ground case, but it's not your loss, because there is a contemplation the property will be transferred on, that there is a duty to account in that situation.
Right.
Where we run into, so I don't really have a difficulty with what's said by Lord Clyde in that. Where we do run into problems is when we look to what Milan and friends say to this court about that. Because they say all of the claims of this nature are subject to a duty to account. And I say, well, why? If it's the performance interest, who are you holding that on duty to account to? A broader ground case, it's your own loss. Why is there any duty to account? And what's the provenance of that duty to account?
Yes, I see. So you say Lord Clyde is really a version of the narrow ground.
Yes.
And the problem we have here is that the narrow ground is not what's being relied on.
Correct. And nor is the broader. Nor is the broader. And it's important we recognise this, that the appellant comes to this court and says there's two recognised bases. There's a narrower ground, that's definitely the law. There's a broader ground, that might be the law. I can't meet either of them. But I have a third way because of an obiter comment and an obiter comment.
Yes, but they are expressly suing on behalf of the third party.
They are.
So it's not a broad ground claim.
It's never been a broad ground claim. That is absolutely fair.
That's not how it's pleaded.
Exactly so. And to be fair, it's always been accepted that they can't get home under either the narrower or the broad. It needs to be something of the way of Lord Drummond-Young's all-encompassing last sentence. It just applies wherever you can show loss suffered by breach, which can't be right.
Could I just clarify one point, if
Lord.
I may? You say, and I see the force of it, that whether it's the narrow ground or the broader ground, as we've discussed, the appellant cannot succeed. But at the same time, rather like a deus ex machina, you bring in these two Scottish cases of Bloom and Edinburgh United Breweries, which would potentially challenge the existence of either of those grounds.
I do.
Where's the respondent's stance? I mean,
so do
you accept the existence in Scots law of the narrow ground?
So that's why I put it the way that I did after introducing this, which is it's a terribly cowardly way to proceed. But I'm here to meet the attempted development of the law. I have not, until I saw what was in Gloag, I have not attempted at any point to dispute that the narrower ground is part of the law of Scotland, which has been the assumption.
Yes.
Well, and it's derived from Dunlop and Lambert, which of course is a Scottish case in the House of Lords.
Indeed.
I've had a look at the House of Lords judgments in the Edinburgh Breweries. In the Edinburgh Breweries.
Yes,
United Breweries.
And they don't discuss Dunlop and Lambert and all that line of authority.
No.
A lot of it seems to turn on the effect of a conveyance in superseding previous missives. Which is quite a different point.
It is, but they do expressly engage with the question of interest to sue on the basis that neither party had it. In truth, the real problem for Milan and Friend or for anyone arguing that the narrow ground is part of the law of Scotland is the case of Bloomer. That would have been a case which, if we'd been cited on it, and we just looked at page 350 of Gloag as well, because Lord Clyde very rarely gets things wrong, it was only when Mr. Reid found 254 that we thought, well, hang on a minute, even the narrower ground might be suspect. Of course, this court has no such impediment. Yes, if this court says, well, that's all very interesting from Bloomer from the late 19th century, but the world has moved on, and the acceptance on the basis of Albazero, albeit on probably on the basis of a misconception, but the acceptance of Albazero and Panatown of what is meant by Dunlop is such as to say that's part of the law of Scotland as well. So I don't urge upon the court a conclusion that even the narrower ground's gone.
No.
I don't say that. But what I do say is, on the law as it stands, it is difficult to argue that the broader ground exists. There's no support for that. And a fortiori, the even wider expansion of the law as it stands, argued for by my learned friend, simply does not wash. It has no foundation. And ultimately, what I say to this court is, this is not a case where there is any true uncertainty as to the law. The general rule that a party can recover only its own losses is surely not disputed. And the narrow ground exception is not disputed. What is disputed is whether, in addition to these settled principles, there exists an entirely new, radically wider doctrine which no court has ever recognised, no academic has ever formulated, and which even the Law Commission has been unable to recommend. The true complaint is not that the law is unclear, it's that the law doesn't produce the result the appellant wants. Well, that's not a basis for making new law, particularly new law whose consequences cannot be foreseen and whose scope cannot be defined. It's not a plea for incremental development of the common law. It is the incitement of judicial vandalism. And I suggest that we get a lot of good sense if we go back nearly 200 years. Baron Alderson in Winterbottom, quoted in Donoghue against Stevenson, page PDF 415.
415.
415, my lady, yes. Winterbottom itself is in the bundle, but the passage I'm interested in is quoted by Lord Buckmaster at 415. The only safe rule is to confine the right to recover to those who enter into the contract. If we go one step beyond that, there is no reason why we should not go 50. That observation nearly 200 years ago has lost none of its force. What the appellant proposes is not one step, it is 50 steps, taken in a single bound, without a map and with no way back. That is not something which this court can contemplate. And for those reasons, my lords and my lady, and subject to any questions from the bench, in my submission, this appeal falls to be refused.
Have you read Bloomer? I'm wondering if you've read Bloomer. I'm just looking at it for the first time, and from the head note, it looks as though it may not be directly in point. It looks as, according to the head note, shipbuilders sell an unfinished ship. They subsequently enter into a contract for work to be done on the ship. The work isn't done, and they and the purchasers then sue the person who should have done the work. And all that's decided is that the purchaser of a ship has no claim because he wasn't a party to the contract, and the terms of the contract didn't confer on him a jus quasitum tertia. So it doesn't seem to be, at least so far as the head note goes, it's not deciding anything about the position of the shipbuilder.
Well, it does. If your lordship reads on, the instance, because Bloomer and Co. were also failed. And this is, from my I perhaps should have provided Bloomer, but having looked at it, my understanding is Gloag's distillation of it is correct when Gloag says the instance of Bloomer and Co. also failed in respect that they had no interest, as they were not liable for the delays of the engineers, and that they had as they had no interest in the ship, they had suffered no loss, and were therefore suing for damages which they had not sustained. And that was because in their contract, they had protected themselves from any liability for late delivery owing to fault on the part of the engineers, which is the exact analogue of here, Clause 8 in the licence, not liable for any state of the premises. So it's frankly, it's directly against the narrower ground, but as I say, I'm quite content to accept that the world has moved on since then, but it doesn't support my learned friend's case.
Okay, well, we'll just have to read the case.
My Lord, I'm terribly sorry. There was one thing your Lordship asked me about Australian law or Commonwealth. Again, great thanks to Mr. Reid. Panatown Albazero hasn't really been considered by the High Court of Australia at all. It's quite remarkable. But that's perhaps because the doctrine doesn't seem to have been accepted into Australian law. And we see that from two cases, both fairly recent. Central Coast Council, 2021, New South Wales Court of Appeal 75, where the court said the approach in Linden Gardens has not been accepted in this country, not this state, in this country. And similarly, Yuan, Y-U-A-N, and O'Neill, 2020, South Australian Supreme Court at 49. Again, the Australian, as I say, not the High Court, but the level below that in terms of state, saying that the Albazero exception has been accepted in a very much more narrower way in Australian law, but the whole broader ground aspect and even the narrower ground not applied in the same way under the law of Australia.
Well, that's very helpful. Thank you and thank you, Mr. Reid, for the assistance. Yes, Mr. Thompson.
Lord, just a few points by way of reply, and I would like to begin actually with the recent question posed by my Lord Hodge relative to some of the authorities relied upon by the respondent, because that question and my learned friend's answer to it exemplifies actually what most of my response to my learned friend's submission actually is, which is the force of the submission made on behalf of the respondent is effectively to deny at every turn the logic of allowing transferred loss claims at all, in any form, in any shape, whether on the broad ground or on the narrow ground or on the ground for which I contend. So at every turn when the court reflects on most of my learned friend's submissions, what one will see is that they amount effectively to a rejection of the very idea of transferred loss. And so far as, for example, the passage in Gloag is concerned, so far as the reference to Winterbottom is concerned, if we go one step beyond restricting a claim to the parties to the contract and the loss suffered by them, we must go 50. On any view, in my submission, the law, I'll come to Scots law in a moment, but the law on any view has moved on very significantly since then. We have had the development that started in Dunlop against Lambert, that was expanded in the Albazero, that was expanded in Linden Gardens, and when Panatown came round, again, a further extension. So much of the force of what is said against me in my submission has to be seen in that light. That takes me to effectively where the parties part company at a very early stage. My learned friend says that the case for the appellant involves a completely new doctrine that is entirely unprecedented and entirely unsupported by authority, and that it indeed is contradicted by authority. My submission is to the contrary. If one is looking at the Scottish case law, there is no hint in the Scottish case law of the adoption of the narrow or the broader grounds as they are discussed in the English authorities. And rather, one has the speech of Lord Clyde as interpreted and glossed by Lord Drummond-Young, and then as subsequently interpreted in the Outer House. So that in turn takes me to the reliance by my learned friend upon cases such as OBG and Allen, and the suggestion that this court should be extremely reluctant to develop the law, overturn established principles of the common law, and so on. My submission is that one is very far removed from the types of situation that were in contemplation in those cases. One particular feature of that is the submission that my learned friend the Dean made about the fact that Parliament has recently intervened in the form of the 2017 Act, and that there has also been consideration of matters by the Scottish Law Commission. So, in relation to that, the Scottish Law Commission produced a report that was the precursor to the 2017 Act. That was report number 245. In that report, it was expressly stated at paragraph 1.22 that the Commission intended to address the question of transferred loss later. So the report that led to the 2017 Act is not the 2018 report number 252. When one gets to the Scottish Law Commission's report number 252, it is correct that the Commission conceived that what one would take from the Scottish case law is that the narrow ground appears to be what was accepted in the Scottish cases to date. I've already observed that in my submission that cannot be correct, not least because if one takes the example of Lord Docherty's opinion in Axon Well, that was a case where the transferred loss claim related to loss of profits. And it was nothing to do with the transfer of property either. So the position is that Parliament has not been called upon by the Law Commission to legislate in this area. The legislation that Parliament did enact was the product of a separate report. And it's true that the Scottish Law Commission ultimately offered the view that it was unable to make recommendations. But in my submission, if I'm correct in my characterisation of the state of the law at the moment in Scotland, it is not the appellant that is inviting this court to embark on a radical reformulation of the law, but rather to proceed on the lines that have been set in train for some time already. And indeed, if one read, for example, Professor McBride's work on the law of contract in 2007, my submission is one would see that the articulation of principle there is consistent with the general approach for which the appellant in these proceedings contends. Thinking again about whether the case for which the appellant contends is wholly unprecedented and a remarkable extension of the law, so far as Lord Drummond-Young's opinion is concerned, at paragraph 30 of the respondent's case, it is observed that the case for which the appellant contends is of very considerable width, is how it's put. It's then said that Lord Drummond-Young's obiter dictum in McLaren Murdoch is similarly wide. And indeed, I think that would be a fair understanding of the submissions the Dean has just made, that Lord Drummond-Young's articulation of the principle is extremely wide. Then, far from saying that the principle or proposition for which the appellant contends is unsupported by authority, the respondent then actually argues that the appellant in these proceedings is seeking to narrow the principle from what was articulated by Lord Drummond-Young in McLaren Murdoch. That also is found in paragraph 30 of the respondent's written case. So that the point of departure for the parties in my submission is at this very early stage as to what the state of the law in Scotland at the moment actually is. I wanted to turn briefly then to the position in relation to the licence. It was repeatedly submitted by my learned friend the Dean that it is to be regarded as an unlawful licence. For the absolute avoidance of doubt, the appellant disputes that the respondent has ever put that in issue. If it had put it in issue, it would have been responded to, And in short, the appellant does not accept that this respondent would ever be entitled to say that it is unaware of and objects to the licence in question. So far as the provisions of the licence are concerned, however, and in particular the fact that there is no liability inter se as between the tenant, present pursuer, and the licensee is concerned, at paragraph 63 of the respondent's case, the argument is made that this would create a significant anomaly if there was an ability on the part of the pursuer to recover damages in a situation where it was not liable to the licensee. There are two things to say about that. First is, if there were such a liability between the present pursuer and the licensee, there would not be a transferred loss claim, of course, because the present pursuer would simply be suing for its loss in the form of the liability that it incurs to the tenant, to the licensee, for a breach of that contract. In my submission, however, the absence of any liability as between tenant and licensee does not operate so as to exclude the availability of a transferred loss claim, and in that respect I place reliance upon what Lord Clyde said in Panatown at page 531H to 532B, which is pages 818 to 819 of the bundle. The 2 points to note from that passage are these. First, the thing that has been found to exclude the availability of a claim for transferred loss are where there is the conferral of a direct right to sue on the part of the third party, which would either in Scots law arise by the existence of a jus quaesitum tertio or some contractual provision to that effect. So that's the thing that has been found to exclude a claim for transferred loss. But at page 531G to H, Lord Clyde did identify that the arrangements between the party to the contract on the one hand and the third party on the other might serve to exclude the availability of a transferred loss claim. But as his lordship put it, the law would be slow to find such an intention established where it would leave the black hole. So the law will be slow to exclude the transferred loss claim on the basis of arrangements between these parties, and that, of course, in my submission takes one back to the observations I made earlier that the arrangements between these group companies should be a matter of no material concern to a person in the position of the present respondent. And I also made the observation earlier that one could say that in almost every transferred loss claim. The final points are these, my lords. It was submitted by the Dean that there is a irreconcilable tension in the arguments for the appellant so far as the question of intention is concerned. His submission was, how can it be irrelevant to the availability of a claim for transferred loss on the one hand, and yet relevant to the foreseeability and recoverability of damages? That point is answered by Lord Clyde at page 530 C to H, page 817, where his lordship explains that foreseeability is relevant.
I'm sorry, but could you give us that reference again?
Sorry, my lord. Page 817, so it's of the bundle, page 530 of the report between C and H.
Thank you.
Where his lordship contrasts, on the one hand, why intention is not relevant to the availability of transferred loss. It's a solution imposed by law, but on the other, that it's relevant to the question of foreseeability of damages.
Okay.
And in that respect, I just wanted to make this observation. I think it was submitted by my learned friend that a difficulty for the appellant in the present case is that the claim for consequential loss of profit, he said, would be a claim in the second limb of Hadley and Baxendale. Well, in my submission, that's not correct. At least if what would fall within the second limb of Hadley and Baxendale as if there was some special, unusual feature of the types of loss that might be incurred that would have to be within the specific actual contemplation of the parties. Here we're simply talking about, in my submission, losses that, as to their character, arise in the ordinary course of things. So we're in the first limb of Hadley and Baxendale in my submission. The final point is really just this, so far as the duty to account is concerned. For the avoidance of doubt, the appellant is not saying that in all cases, whether characterised as narrow, broad, or the third way for which the appellant contends, there will always be an obligation to account. And the Dean highlighted the difficulty in accepting that as a matter of logic in the case of broader ground claims. And I absolutely accept that, but the answer to it is the broader ground on closer analysis is not a transferred loss claim at all, because the pursuer is simply suing for its own loss. The case for the appellant is that Scots law on the authority so far has not received the narrow and broad ground distinction. We're left with, in the case of actual transferred loss, it's baked in to the concept of transferred loss that as a matter of law there is an obligation to account, and that obligation to account must arise on the receipt of the damages. It can't pre-exist, because unless and until the damages are recovered, there is nothing to account in respect of. That was all I wanted to say by way of reply, unless there's anything the court wishes to raise with me.
Thank you very much indeed, Mr. Thompson.
Obliged.
Well, yes.
I'm not seeking to make any further argument. I forgot to say this. In terms of disposal,
Yes.
it is simply a question of the court either allowing the appeal or dismissing the appeal, and on any view there is no requirement for any submissions on costs, because there will be no cost consequences to either party standing the settlement. I'm sorry, I should have mentioned.
That's very helpful. Thank you very much.
Could I just clarify that, if I may, please? Given the settlement, there are no pleas in law that you wish to be upheld or anything of that nature.
Correct.
You really just want a judgment on the law.
That's the common position of both parties. On that point, at least, we're agreed.
Okay.
Obliged.
Thank you.
I think the only thing to add is it would follow that the case would have to be remitted back to the Inner House. The parties will then dispose of it per their agreement before the Inner House.
Yes, that's very good. So we remit, and then you will then file a lodge a joint minute in the Court of Session.
Indeed.
Yes. Well, we're most grateful to Counsel for their assistance. This is, as Counsel will appreciate, and any law students or lawyers in the room will appreciate, this is a very important case for Scots law, for Scots law of contract, and it's not at all easy. We've been greatly assisted by very skillful advocacy, and we're grateful for that. We'll have to take some time now to consider the judgment that we'll issue. The court adjourned.